Oh, sure.
The House Judiciary Committee will come to order. We will be taking up House Bill 4666 and 4670, and I have a few cards to read here. Supporting the bill is Dina Swisher of the Michigan Certified Michigan Court Officers and Deputy Sheriffs Association. Also supporting the bill, Jeff Kirkpatrick of the Michigan Court Officers and Deputies Association. Neutral on the bill is Peter Cunningham of the State Bar Association. So back to our...
Are you relating to 4666?
yes, those cards, yes.
Can I ask one simple question?
Sure.
Does the criminal penalties apply to the sheriffs and the other officials?
We passed out, which somebody could slide you a copy, that they're already under penalty of perjury, police officers are.
What's the penalty, what's the maximum max?
15 years in prison, $1,000 fine.
As for processors?
Would be the same for the processors with this bill. And neglective duty of $1,000 fine as well. For police officers,
A misdemeanor, yeah.
yes. So I need a motion to move move and adopt the substitute for H3 for House Bill 4666. Representative Tice, will the clerk please call the roll?
On the motion to adopt substitute H3 for House Bill 4666, Chair Runstead.
Yes.
Representatives Tice.
Yes.
Howerlag. Cole.
Yes.
Hornberger.
Yes.
LaFave.
Yes.
Grimal.
Yes.
Robinson.
No.
Guerra.
Yes.
Sowerby.
Yes.
Mr. Chair, you have 8 yeas, 1 nay, no pass. Substitute H3 is adopted.
Thank you. Representative Tice moves to report House Bill 4666 with recommendation as substitute H3. Will the clerk please call the roll?
On the motion to report House Bill 4666 with recommendation as substitute H3, Chair Runstead.
Yes.
Representatives Tice.
Yes.
Howerlag. Cole.
Yes.
Hornberger.
Yes.
LaFave.
Yes.
Grimal.
Yes.
Robinson.
No.
Guerra.
Yes.
Sowerby.
Yes.
Mr. Chair, you have 8 yeas, 1 nay, no pass. House Bill 4666 reported with recommendation as substitute H3.
Thank you. Representative Tice moves to adopt substitute H2 for House Bill 4670. Will the clerk please call the roll?
On the motion to adopt substitute H2 for House Bill 4670, Chair Runstead.
Yes.
Representatives Tice.
Yes.
Howerlag. Cole.
Yes.
Hornberger.
Yes.
LaFave.
Yes.
Grimal.
Yes.
Robinson.
No.
Guerra.
Yes.
Sowerby.
Yes.
Mr. Chair, you have 8 yeas, 1 nay, no pass. The substitute is adopted.
Thank you. Representative Tice moves to report House Bill 4670 with a recommendation as substitute H2. Will the clerk please call the roll?
On the motion to report House Bill 4670 with recommendation as H2, Chair Runstead.
Yes.
Representatives Tice.
Yes.
Howerlag. Cole.
Yes.
Hornberger.
Yes.
LaFave.
Yes.
Grimal.
Yes.
Robinson.
No.
Guerra.
Yes.
Sowerby.
Yes.
Mr. Chair, you have 8 yeas, 1 nay, no pass. House Bill 4670 reported with recommendation as substitute H2.
Thank you. And now we will return to consideration of House Bill 4158. And we have Attorney Michael Corman here with some of his clients. If you'd please come forward and begin when you're ready.
Good afternoon. My name is Michael Comorn. I'm a criminal defense lawyer. I've been practicing for about 25 years. I'm also the president of the Michigan Medical Marijuana Association. I want to thank the chairman and the Judiciary Committee and Representative Lucido for championing this important cause that, from my personal experience as a lawyer, has been quite brutal on the citizens of Michigan. With me are two clients of mine that I've represented in court proceedings. Both I would describe as being victims of both the Michigan Medical Marijuana Act bad interpretations and also forfeiture law. And we've submitted for review, I have like an index of various events that have taken place in some cases that I think evidence or should hopefully convince you that there are some real problems with the existing forfeiture law. And I want to just point out there's some very unusual things that are unique to forfeiture law that are uncommon to the principles of governance that we understand. Like the Michigan Medical Marijuana Act, there's this concept of immunity, and in forfeiture there's this concept of constitutionally protected property. And what unfortunately happens is both the person's immunity and their right to property is determined at the time by the police without any kind of due process. In other words, there's, unlike a driver's license or some other entitlement that the government gives, there's no hearing between a neutral detached magistrate. To get a search warrant, we require a independent, neutral, not the police making the decisions when they can go into a home. This does not take place with forfeiture. They're inside of a home, they're executing a search warrant, and it is they that decide what property is subject to forfeiture. And they also decide that the person is outside of compliance with the Michigan Medical Marijuana Act, which is not always the case. And the reason why these individuals are here is really to emphasize the point that they are people that were charged with crimes and utilized the Michigan Medical Marijuana Act to defend and or have the charges dismissed. And independent of that, they still were victims of forfeiture. Ms. Jocelyn had her house forfeited with the Attorney General's office, and it turned out a year later when she was charged criminally, it was an illegal search warrant that was found, and all the evidence in the criminal case was thrown out. Had this law been in effect, she would not have been subject to that particular forfeiture of her home. Mr. Fisher defended himself under Section 8 of the Michigan Medical Marijuana in Isabella County. There was a forfeiture proceeding that had been stayed pending the outcome of the criminal case. The criminal case resulted in a dismissal of all charges. The MMA says if you prevail under Section 8, there shall be no forfeiture. And when we went to try to get the property returned, the prosecutor's office filed a motion to recuse the judge. Recuse the judge because one time, 17 years ago, the judge made a negative comment about forfeiture. Things are getting strange, and things are very unusual amongst government officials in this arena. And after litigating that and having the court find that the judge should not be disqualified, we got an order to return the property. My client went out to return the property, and they still haven't returned all of the property. This is abnormal behavior. There are things that I think most citizens wouldn't expect to happen. Oftentimes I have to explain to clients not just why the police think they violated the Michigan Medical Marijuana Act, but I have to explain to them the forfeiture law, how they have to fight to get back their property. So I want to have my clients speak as to their experience, but from my perspective, my experiences is that there is a rampant abuse, and I think the statistics speak for themselves. 2012, $25 million brought in on forfeiture proceeds, and this last year reporting $15 million. I always understood that the legislature was the one that created the budget, had the purse strings. I don't know of any other government agencies that are given a budget and then go out and earn money on top of that and use the money for their own purposes, and that is the system that's been set up. So I'd like to let my clients speak a little bit, and I would encourage you to vote in favor of passing this bill.
Hi, thank you to the committee for hearing us today. My name's Amanda Jocelyn. I'm a caregiver, I'm a patient, I'm a mother, daughter, neighbor, and a friend. I'm a law-abiding citizen, and I'm also a victim of policing by profit. My son and myself were raided, jailed, and prosecuted by the state for medical marijuana, and some of the same behavior that is currently being licensed. The activities are being licensed right now. I'm in support of the bill 4158. In 2015, after receiving local approval, the state of Michigan raided my home, seized my property, money, closed my businesses, took my cars, home, computers, my kids' game systems, My son had been saving his paycheck since he was 17. He was 21 when this happened, and all of that was gone. And you tell a 21-year-old something like that, you know, I'm sorry, but the police and the government won't give our stuff back. And this was all prior to us being charged, by the way. When the forfeiture took place, there were two separate cases, the criminal and the civil. The civil had already been given away by the time the criminal case had been concluded, which, as Mr. Comorn mentioned, it was dismissed for a violation of civil rights. So, or, excuse me, Fourth Amendment. So, you know, I see that there are staggering statistics out there on the arrest rates for rape at 14%, murder rate, arrest rate is at 30%, and then the drug arrests are at 80%. And we take a look at that and we wonder what the motivation is. Well, we can't take money from a sexual offender. We can't take money from a murderer. But we can, however, take money from the low-hanging fruit, which is the medical marijuana community, and seize all their assets. We have individuals that are participating in a consensual act, and they're being wiped out financially, emotionally, spiritually, just broken. No means of hiring attorneys or even feeding their children. And again, there's no money to prosecute or to arrest rapists or murderers, so the low-hanging fruit is what is picked. My two sons and myself are three of the many Michigan residents that fell victim of policing by profit, and we are victims of the drug war. Interestingly, many of which, not only myself, in many cases, these folks are never charged with a crime. However, all of their things that they've worked for so many years are just gone. And imagine, if you will, having a complete stranger go and rifle through your closet, your drawers, every little private nook in your home, and just throw it all over the place and then take and pick and choose what they'd like to take home with them. They took even a steam mop. And all of this was based on an illegal search warrant, and they took all of that. To this day, my son struggles with severe anxiety. He struggles with depression. He was 21 at the time this happened. He's 24 now, and he still has not recovered. Passing this bill is going to help to mitigate the law-abiding citizens of Michigan, the good citizens, good people of Michigan, from facing the devastation that civil asset forfeiture brings forward. Thank you for your time, and we rely on you to make Michigan a safer place in that regard.
Thank you. I believe we have a question from Representative LaFave.
Thank you, Mr. Chairman. Miss, I'm so sorry to
Ms.
hear.
Jocelyn. Yeah.
Miss Jocelyn, I'm so sorry to hear that this happened to you.
Thank you.
I'd like to know, when the property was seized, at what point and what portions have you had returned to you, and how long did it take to get any, if any, of that back?
It's more of a procedural issue. If I could, the raid took place. She was served with the forfeiture action, attempted to seize her home and the contents therein. I was not represented at the time, and there was no insight, any criminal charges, or we weren't notified that it was going to happen. She ultimately settled with the prosecuting attorney's office and walked away with whatever she could, but she had to give up her home. She had to pay another $10,000 when her home was sold, and the proceeds of which went to the state of Michigan. So it wasn't until a year later that the criminal charges were brought, and then I began representing her, and we defended, and it turned out there was an illegal search warrant.
And if you can, please.
I'm sorry. So none of the things came back. They're gone because there's a separate proceeding.
And then, if I may, so there was no percentage in that settlement that you had? There was no percentage of, like, being able to get your son's piggy bank back, or
It was
anything like that?
That's fine.
Unreasonable.
Nothing of substance. She gave up her house.
You might have got your mop back, but you didn't get your car.
I didn't get, no, nothing, actually.
Amount
So
did not get-
it was unreasonable terms that were put forth, and after being devastated like that financially, and there's not really a means to pick up and pay more. You're paying for legal fees and all of these other things that go along with living expenses. I didn't have money for my house payment, even if I had nothing.
Thank you, Mr. Chairman, and thank you for sharing your story with us today.
Thank you very much. Do we have additional testimony, or?
Steve Fisher just wanted to comment if he could.
Sure.
Representative Cole is back.
Okay. Representative Cole does have a question.
Thank you, Mr. Chair. What year was the search warrant issued?
2015.
2015.
2015. What was your primary income source in 2015?
I had a doctor's office that I ran,
Okay, right.
and I had a few other income streams in addition to that,
Okay.
self-employed, but
But the reason I ask, if I may, Mr. Chair, is I believe the original way that the medical marijuana bill was written, that it was not to be profitable, if you will, when you're providing for patients. That's why I asked about that. So that wasn't your sole source of income.
it was not, no, it was not.
Okay, thank you. Thank you, Mr. Chair.
Go right ahead.
Thank you. Thank you for your time today. Just like to say a few words in support of Bill 4158. Like those before me, I'm also a victim of civil asset forfeiture as of April of 2016. I'm 51 years old, and my name is Steve Fisher. My wife, Leslie Fisher, is also included in this. We were raided in April of 2016, and the cops proceeded to take a bunch of our property, things that they deemed were of value to them. A little bit about myself. I served in the Army from 1985 to 89, and shortly after that, I started my own business, a landscape company, which I ran for 19 years after that. And then I sold that business in 2013, and since then I've been running electronics recycling business. So I've been a little self-sufficient, you know, with feeding my family, taking care of ourselves, paying the bills. My wife worked at the casino for over 22 years. And so you know, when I served in the military, I gave the United States a blank check with my name on it. And that check said, cash at will. And I was better for the service to my country. I'm proud of it, and proud of what all of it stands for. So for me to have to sit here and explain that the civil asset forfeiture law is flawed, that it needs fixed, that the execution of it has been abused by law enforcement, and that prosecutors vigorously fight to try and keep my property even after a dismissal, is quite disturbing to me. My wife and I didn't even have our day in court, but yet we were being punished prior to that, in the sense that they'll take your property, albeit economically. They were supposed to take things that they believed were linked to a crime. A perfect example of how law enforcement's total disregard for this is the fact that they took a car that I bought brand new in 1987. The car had less than 30,000 miles on it, and the last time it was plated was in 2009 or 2010. So I can't get my head around how they justify taking property like that. That has nothing to do with anything. And I guess I need to mention that me and my wife were medical marijuana patients, and I was her caregiver. I didn't caregive for anyone else at the time. Another thing I wanted to add too is, back when this happened, we also had to pay the bond that they were allowed to put on the property at the time, just so we could have our day in court to fight to get our property back. And again, I'd like to thank you guys for this time, and I am in support of Bill 4158. Thank you.
Thank you. Any questions? Representative LaFave.
Sir, thank you, Mr. Chairman. Sir, I thank you for your service to our country. We can't have hearings like this without brave men and women willing to pay the ultimate sacrifice. If you're not comfortable answering any of these questions, totally understand. Just background about how many plants did you have in the house, and approximately what items, the laundry list of such, did they take from your home? And last question is, what, if anything, did you get back at the end of it?
Right. That's a very good question, and I'd like to answer just in this regard. And this is the point I was trying to make, because your question would suggest, well, maybe the police were justified in doing what they did if he was way outside of his compliance or whatnot.
And I don't mean to suggest that in any way.
Understood, and I think it's an important point to make, which is that the decision of this noncompliance is being done by the police, who, if they make that determination, the individuals are no longer immune, and the way the law has been interpreted is that marijuana is still illegal in the state of Michigan unless you're immune from it because you fit this narrow category and volume limitations. Now, the volume limitations, which was the issue in this particular case, deals with a specific term of art, which is usable marijuana.
I'm familiar.
It's got to be dried.
Yeah.
Now, when a patient harvests 2, 3, 4, 5 plants of the 12 or up to 72 that they have, they've got soaking wet plant-like material. Law enforcement does not contemplate this. They call it processed. I remember at a Judiciary Committee in 2011 when Representative Horn asked someone from the Michigan State Police, in light of the definition of usable marijuana, what does the Michigan State Police have to say of that? And they said, we do not have a comment. Okay, now, the significance of that was the issue of usable marijuana remained elusive. It was not defined. And therefore, this wet plant material, you could go in and say it weighed 20 pounds, which is what is common. I have hundreds of cases like this, when in fact, it wasn't dry. It was not ready for use. And the purpose of the law was to protect people from arrest, not create nuances that, exceptions that could pull people out of their immunity. And that is unfortunately what has been happening. You wouldn't see an increase in arrests of marijuana 14% every year and 15 million in proceeds when you have a state law that was intended to stop that behavior. I mean, the legislature in 2016 amended the law retroactively. I've never seen this before in 25 years of practicing law, retroactively to cure what the legislature has been unable to do, which is to protect patients from getting arrested. I mean, that's a declaration that the law has not worked with its original intention. And the statistics show it, because you've got an increase in funds and an increase in arrests. So the point is that the allegations through the eyes of law enforcement are not, and again, it's not their fault, I would even say. They were not educated on this. It's a new area of, and that's been an unfortunate fact. But these things that I'm talking about have been used, unfortunately, to promulgate and increase the forfeiture proceeds. But the allegations were, of course, about issues of usable marijuana. They find them on a drying rack, intending to be drying, not dried. So things like that have been, play on words to pull people out of immunity. And it is a good point and very good question. Thank you.
Well, it's a Section 4, not Section 4. If you're out of Section 4, then they see it as a free-for-all.
That's true also.
Then they hit
Okay.
you hard. And it's like Section 4 exists, Section 8 does not exist.
Well, if let's skip that then. If you don't mind, just briefly give me the list of property that was seized and what, if any, was returned.
They took 2000 Cadillac Eldorado, 2009 Chevy Silverado, the 1987 Buick Grand National, all my guns, 6 guns, all the ammo, gold and silver that I had in the house from my recycling business that I reclaimed myself from circuit boards. A trailer, 14-foot enclosed trailer with snowmobile in it. All the grow equipment that I had. I also had a extraction equipment to make concentrates. What else did they take?
And we,
And the list goes on. So, it was things of value and things that were easy to take. They just cherry-picked us. And we ended up getting all the vehicles back, the enclosed trailer, the snowmobile, some power tools, my cordless drill, table saw, 2 computers. Funny thing is they took a computer out of my house. I had, in my office in the house, I have 2 desks. I have, one desk is, I do everything but pretty much email on that. So I got some computer games on there. They took my gaming rig and left the computer that I do all my emailing on.
Okay, we got to move along. We got a number of additional people to testify. If there's no additional questions, Representative Cole.
What year was the search warrant and the item seized?
2016.
2016?
And we just,
Yeah, that was
when
him.
was it? December 20th, I think it was, we just got some of the stuff back. But the court order was to return all the property, all seized property. Prosecutors refused to give it back to us.
Currently under law, is it legal to possess marijuana and firearms at the same time?
Well, that's a good question. You know, the MMA keeps private the names of the registry of who are the patients, and there is obviously a Second Amendment right to possess. I know that the ATF has commented on this under the pretext that under federal law, all Schedule I drugs are, addictive. And
So, what I'm getting at is there maybe was just cause to retain some of that property during the search of that, and that some of that was obtained potentially with monies derived from the sale of marijuana. Is that, I'm just trying to wrap
No,
my
I
head
understand.
around the whole scenario
I
here.
understand. But you have to understand, what I just answered is the ATF, under federal law, this is the state of Michigan, they have a Medical Marijuana Act, and the state just
But the
passed laws.
scheduling, sir, of drugs at the federal level supersedes the state.
Yeah, but this is a state court we're in, it's the state
Okay, all
laws
right.
we're under, it's not a federal prosecution.
Understand.
They don't apply federal law in state court, and the concept of, that you're speaking of it being, Schedule I, is absurd. This legislature just passed a law where they're going to receive tax money for selling these things that this argument would lead to, that my client was possessing, and it's contraband, may as well be kiddie porn. I mean, that's the analogy.
Was extraction legal when the search warrant in Michigan, when the search warrant was issued?
That's a good question. I don't know that it was ever illegal. I know that there was an opinion about brownies, but I would suggest that the preparation thereof of the Michigan medical marijuana, usable marijuana, has never been litigated. Now, I know law enforcement was arresting people if it wasn't plant material, but that was not a resolved issue. I would say brownies maybe, but that this legislature fixed. And the real answer is no, it wasn't, because the law that you pass is retroactive. So the answer is no. When he was possessing so-called extraction machine, asking me today, it was lawful because the law is retroactive.
Another issue too is
Right?
they claimed that was sold.
I'm just, thank you, Mr. Chair, for allowing this, but I'm just trying to wrap my head around if the law enforcement agents may have been acting in lawfully under what they presumed was the intent of the law and how the law was written at that time that they made the entry into the residence and seized the property.
Understood. His wife was not bound over, meaning the charges were dismissed against her. So that would be the first answer to whether the law enforcement were acting appropriately. There was no probable cause to find that crimes existed in the case. Now, Mr. Fisher's case, we had to litigate, and ultimately it was, the court found that there was a medical use, the medical use defense was found to result in the dismissal of the charges. But his point is making that no one recognizes that there's this medical purpose, and if you prevail, then there is no forfeiture, and they're not contemplating that.
Thank you.
Thank you very much. If there's no additional questions, thank you for your testimony. Next, we have Ted Nelson of the Michigan State Police, retired, who is supported the bill and would like 3 minutes.
Mr. Chairman and members of the judiciary, I'd like to first say I gave my experience out to the clerk to show what my past has been with my careers, and as well as the Michigan State Police, teaching in public education, and so forth. And also my experience with criminal civil asset forfeiture. I spent 26 years with the Michigan State Police, and after I retired, I spent 14 years in public education teaching criminal justice to high school students, and I also taught adjunct faculty at several community colleges in Michigan. So my interest in criminal justice has gone over 40 years of my career. And the reason I'm here today is because I still have an interest in criminal justice. I have several students that I've had that are in criminal justice as law enforcement professionals, as narcotic officers, as lawyers. All over this country, I have students that are working in this criminal justice field. My brother was a trooper. My other brother was a deputy. My brother-in-law was the chief of police. I have 2 nephews that are in law enforcement. I'm from a law enforcement family, and I believe totally in law enforcement, the integrity and trust that has to accompany law enforcement to be successful. My first introduction to CAF, if you don't mind me referring to it as CAF, Civil Asset Forfeiture, was when I was assigned to the Criminal Investigation Division headquarters on a new drug team that was formed called Interdiction and Conspiracy Enforcement. It was known as ICE. That was before Customs changed their name to ICE. We had an Interdiction and Conspiracy Enforcement team. There was 5 officers on that team, including myself, 1 lieutenant and 4 sergeants. Our mission was to interdict drugs, incoming drugs and outgoing cash, to and from Michigan airports, parcel carriers, bus, train, commercial carriers, trying to interdict the drugs coming into Michigan and the money going out of Michigan. We would go to, we were trained at Chicago O'Hare Airport and Wayne County Airport by DEA. We were to do consensual searches at airports of people by talking to them, we walked up to them, introduced who we were, and we tried to ascertain whether or not they were mules, basically, and to get consent to search their luggage. And that sounds funny to go up to somebody and ask them if they're carrying drugs, but you'd be surprised that most people in the airport feel that they don't have the rights that they normally have in the public eye. So they were very often allowed us to search their luggage. The other mission that we had was to investigate large-scale narcotic conspiracy cases, and we were to team up with other agencies, such as Michigan State Police, multi-jurisdictional drug teams, cities, counties, and the federal government to take down the top tier of drug organizations rather than going after the users or the small-time drug people. We were supposed to go after the higher-level dealers. I received a lot of training in civil asset forfeiture through the United States government, the Bureau of Justice. They gave us training. I also attended the Michigan Department of Treasury tax school for 14 weeks, 4 days a week, to learn about sales and use tax. And I'll tell you more about that and why we were trained in that. I was also trained in analytical investigation methods so that we could keep track and chart large-scale narcotic conspiracy cases. With departmental approval, I developed a curriculum for civil asset forfeiture and consent search training. I first brought this to the multi-jurisdictional drug teams, teaching to try to make a standardized understanding of the civil asset forfeiture law and what it was to be used for and what its intent was. I did find that talking to some of the drug teams, that some of the drug teams were basically unloading houses on search warrants for drugs, and this was before medical marijuana, so this was all drugs were illegal at this time. And they basically emptied houses out. And basically, if they needed a couch for their office, they would take a couch. If they thought it could generate some revenue, they'd take that. And them and the prosecutor would make a deal with the criminal case and would negotiate the property and the criminal case. In my opinion, at that particular time, and I still hold that opinion, that was not what the forfeiture law was intended to do. But me being a detective sergeant and training people who were lieutenants and above, as well as the officers, they were running their own operation with the consent of the prosecuting attorney's office in those jurisdictions. I then was on a program called Operation Pipeline. This was a program that was developed to teach all uniformed troopers, as well as other departments and prosecutors, how vehicles were transporting drugs and proceeds back and forth across the state. So my role was to teach civil asset forfeiture, and consent search on traffic stops. I personally believe that both drugs and cash have to be moved physically from one location to another location, and they are meant to be exchanged. So that makes it so that these drugs and cash are moved around the state. And there's only so many ways you can move them. My job was to make officers aware of this and how to interdict the movement of money and drugs. And I felt I was performing a great service to my department and to my community and to the citizens of this state as part of the drug war. Many officers would seize money on traffic stops, and they would call me because I was the go-to person for the Michigan State Police on asset forfeiture. I was the person who was doing the training. I was the one who was getting calls from different officers from around the state. They seized money. They wanted to know what they should do with it. I would ask them what the circumstances were, and then I would open up an investigation on that. If I determined shortly after the money was taken that there was no nexus to drugs, I would tell them to return the money to the person. Do not, I had one case where over $400,000 was found in a truck, a commercial truck, and the guy had it in a suitcase, and he said he didn't believe in banks, and the state police seized it, and they called me and said, what can we do with it? I did a quick investigation, determined as much as I could about this individual. I said, give it back. I see no nexus. I see nothing that indicates, and back then, we used to do drug sniffs, but drug sniffs on money basically is worthless. Dogs can't testify, and all dogs can do is react. So you can't call a dog to the stand. So I felt dog hits alone were not sufficient to indicate drugs, the money was involved with drugs. I taught forfeiture after I left the narcotics unit. I was in investigative resources. I was involved in training of narcotic officers and field detectives. I continue to teach at recruit schools forfeiture.
I think because we've got a lot more cards to go. If you can get to kind of the core of the bill, and if you support the bill, what is the thinking behind that?
Okay. After I retired from the state police, I was into teaching, and several things happened over a period of time, and that is, and I'll just briefly say that the Bennis case in Michigan had something to do with innocent owners and the Fifth and 14th Amendment regarding due process and forfeiture. Medical marijuana laws came into play. Wayne County and their Operation Push-Off, nuisance abatement cases were hitting the papers quite a bit. 18 cities in Michigan had decriminalized the possession of marijuana. There was a lot of issues when it came to medical marijuana, as you all know. So how did this affect civil asset forfeiture? Some cities allowed dispensaries, even though there was nothing in the state law to allow dispensaries, but cities allowed them. The police would come in and raid them and take their assets. Medical marijuana providers would either commit a technical violation, and there would be search warrants and assets would be seized. Why do I think there needs to be a change or to eliminate civil asset forfeiture? Law enforcement is an extremely important vocation in our society. Trust and service to the public is as important today as it was yesterday. I have devoted over 40-plus years serving the public as a law enforcement officer and as a public school teacher, helping to nurture and provide future law enforcement officers and criminal justice professionals. I believe that the policy and procedures of CAF erodes the trust and is perceived to incentivize law enforcement. The vast majority of officers in our state do an outstanding job, and I'm not blaming them for doing what they think they're supposed to be doing. Only you, the representatives of the people, can make changes necessary that will provide oversight that will take CAF out of the shadows and into the light. Over time, our departments and officers will gain respect and trust by the citizens for the public servants that we are.
Thank you very much. Do we have any questions from the committee? Apparently not, so thank you very much for your testimony.
You're welcome, sir.
Next, I'd like to call up John Shea of the Criminal Defense Attorneys of Michigan.
Good afternoon, thank you. I'm John Shea, I'm the co-chair of the Rules and Laws Committee of the Criminal Defense Attorneys of Michigan, and I'm here to testify in support of the bill. There's three main reasons why we support it. The first is because it's proper policy. I consider it a misnomer to call this civil asset forfeiture. There's nothing civil about it. It's a quasi-criminal act taken by law enforcement under the auspices of the state, and it's only taken when a law enforcement officer says that he or she believes that there's probable cause to believe a crime was committed. It's a penalty. It's a penalty that's imposed in advance of adjudication, advance even of a charge, and it's not the way we do business in the criminal world. In our system, we don't let law enforcement make this kind of call. They make the call about whether they think a crime's been committed so they can arrest someone or they can proffer charges to a prosecutor for authorization and things like that. We don't, under the typical system of justice, we think is our typical system of justice, give law enforcement the right to impose penalties in advance of all that. So the first reason that we support this bill is we simply think that imposing a penalty before a crime's been proved is putting the cart way before the horse and is improper. Second, it incents abuse, and you've heard some stories of abuse here. I think it incents abuse. It incents abuses systemically. Everyone can point to a case here, a case there, where something's gone off the rails, but maybe the policy behind it's essentially sound. Here, it incents systemic abuse. We know how much money is taken. We know the circumstances under which they are taken, and it's just too easy. You get a home seized because a police officer believes that there's a violation of the medical marijuana law. You get money in the home seized because the police officer believes that a lot of money around medical marijuana must mean the person is an illegal drug dealer instead of someone who is lawfully in the business of trafficking in medical marijuana. You see it outside of the medical marijuana field. We hear stories of people driving between Chicago and Detroit. They get pulled over, they're young, it's an older car, maybe it's a person of color, there's money in the car, they bring a dog, the dog hits on it, and the police officer uses that as probable cause to forfeit the car and the money. These kinds of things aren't isolated incidents. These kinds of things happen regularly, and that's what I call systemic abuse, and I believe our law incents that kind of systemic abuse. The reason it incents the abuse is the seizing authority knows it forces the citizen to come to them to negotiate the return of the penalty before they've even been charged with anything. They either have to do that or they have to engage in litigation. They got to hire a lawyer like me or a lawyer like Mr. Camorn, and they have to expend precious resources just to get back what's been taken before there's really been any sufficient process whatsoever to determine that it's appropriate to take. It's a shakedown, and it's a shakedown before a defendant has been charged, oftentimes, usually before charged and certainly before guilt. And I should say, oftentimes no charges are brought out of these police-citizen encounters. The assets are taken. The citizen can't afford to be without the car. The citizen can't afford to be without the money. The citizen negotiates the return of the assets, and everybody goes on their way and considers it to be a good business deal done. It's not a good business deal. Might be a good business deal for the system. It's not a good business deal for the citizenry. And finally, it's unnecessary. There is no reason why we can't impose criminal forfeiture penalties after people are properly charged, properly adjudicated of having committed an offense for which a forfeiture is appropriate. It happens in the federal system, and it can happen here. Now, some might say, well, how do we go back and get the car 6 months later that the person was driving, transporting drugs? Well, The way it works in the federal system is, if you go back to get the car and the car is gone, you're authorized to seize substitute assets, which are other assets that the person owns up to the value of the car that now is gone. It can be done, it is done, and it's not necessary that we do it this way. This is why we support the bill, and I thank you for your time.
Thank you. Do we have any questions? Apparently not. Thank you very much. Next, we have Lee McGrath of the Institute for Justice. Begin whenever you're ready.
Mr. Chairman, members of the committee, thank you for the opportunity to testify in favor of House Bill 4158. My name is Lee McGrath. I'm the Legislative Counsel for the Institute for Justice. You saw my colleagues this morning in the video. Scott Bolick is our General Counsel. Lisa Nepper leads our research, and this is the research that Lisa and the team did, an updated version about what they talked about. My colleagues and I support this bill for two reasons. One is that the features make sense, and I'll talk about that. And secondly, it is not radical. If enacted, Michigan would join 4 other Big Ten states: Iowa, Minnesota, Nebraska, and Ohio, and 10 other states outside of the Big Ten. So this is another important incremental change that is the custom of this committee and the custom of this legislature. Let me return to the first point, and that is the point about features of this bill. The first thing this bill does is draw a line. Mr. Chairman, it draws a line, you know, at $50,000. And above that line, nothing changes. Yesterday, today, tomorrow, the day after the governor signs this bill, prosecutors will continue to use civil forfeiture above this line. So any claims that this bill undermines the war on drugs, undermines the seizure and forfeiture of cash on the interstate highways driven by drug mules back to Mexico, that claim is not reflective of the reality that 50,000 and above, the status quo today maintains. The second thing the bill does, the second feature, is it protects people below who have property less than 50,000. It requires a conviction in criminal court as a prerequisite to forfeiture in civil court. Why do we care about that? We care about that because 80% of the cases in Michigan are below that amount. 80%, and the average amount of the forfeiture is only about $3,000. Interestingly, Mr. Chairman, above the $50,000 level is where 85% of the cash is. So what does this bill do? This bill gives greater protection to Michiganders. It gives greater protection in 80% of the cases that constitute only 15% of the dollars. This is what you can support. You can support greater process for people who face a relatively small amount of property and need the help of a defense attorney or a public defender. At the same time, you can support this bill because it is not weak on crime, it is not weak on the war on drugs, it changes nothing for 85% of the money. The second feature in this bill that is very thoughtful, that comes out of the many meetings that we have had with law enforcement, is that below the $50,000 number, where conviction is required, there are exceptions to that conviction requirement. If the suspect is deported, there's no conviction requirement that it kicks in. If there is a plea agreement, there's no conviction required. Implicit in the plea is a conviction requirement being met. And if the property is abandoned, no conviction is required. The author of this bill, Mr. Chairman, has heard through various sources, all the complaints, all the concerns that law enforcement has made over these many meetings, and he has focused this bill on what's important. The 80% of the cases, not the money. The conviction requirement so that the real process is available to people. The real process of the criminal charge as a prerequisite to the civil forfeiture. Mr. Chairman, you have many issues to deal with, but this is a simple one. This is one that the people of Minnesota and North Carolina and Missouri and Oregon and Vermont and Nevada, even New Mexico, a border state, and other states have dealt with this issue. Lucido is not a crazy man. This is a simple, straightforward, due process argument in which you recognize that the forfeiture is a punishment. And if it is a punishment, the first thing that should be due is the determination of guilt. And that's what this bill does. It will help you. It will clarify issues like the cash in dealing with medical marijuana and all those issues as you have old laws and new laws. But at the core of this is the reality that no one acquitted of a crime, no one not charged with a crime in criminal court should lose their property because of the use of admiralty law in civil court. Mr. Chairman, I'm happy to talk to you about any other state that has done this, the work of my colleagues at the Institute for Justice, and why this is such an important piece of legislation. Thank you.
Thank you. Do we have any questions from the committee? Representative Cole.
Thank you, Mr. Chair. Do you know in some of the other states how law enforcement dealt with this? And what I'm hearing from my law enforcement is this is an important tool in their tool chest when working to deal with drug crime and some of the larger crime families and things in the state. How was that addressed in other states? Since you brought that up, that you'd be willing to answer some of those questions.
I will. Mr. Chairman, Representative Cole, so this bill doesn't change seizure law. If police officers of highway patrol have probable cause, they can take the stuff. What it changes is the process relating to litigation. It changes the forfeiture litigation. It changes the litigation associated with transferring title from the person to the state of Michigan. So a couple of these states, Nebraska, New Mexico, and North Carolina, have eliminated civil forfeiture and put it all in one process of criminal forfeiture. The other 11 do what Representative Lucido is suggesting, keep the two-track system, but convict first as a prerequisite to forfeiture. The bottom line is, the police in Michigan will continue to seize property if they believe there is probable cause to seize it. What this bill changes is the work of prosecutors in courtrooms and as part of plea agreements in terms of doing the hard work, the work that is inherent in the concept of due process, the work of charging someone with a crime and convicting them as a prerequisite to the punishment of losing property.
Any other questions? Apparently, oh yes, Representative Robinson.
$50,000. Anything about that, the dual system, you know, it's the old way with the over 50,000.
Mr. Chairman, Representative Robinson, nothing changes on the interstate highways of 94 on the westbound routes when there are big trucks with over $50,000 seized. You have the same wrapped in plastic, those few seizures that take place. That world is unchanged. You can be tough on crime, you can be tough on drugs, you can continue to, law enforcement will continue to use civil forfeiture above $50,000.
If there's no other questions, thank you very much for your time.
Mr. Chairman, it's always a pleasure.
Thank you. We have 2 more cards here, and we are going to have to kind of really keep these to a limited time. We have Steve Miller in support of the bill he's a retired Canton police officer.
Hi, and thank you for having me today. My name is Steve Miller. I have just almost 25 years law enforcement experience. Started with the United States Air Force Security Police right out of high school. Did a tour in Desert Storm in Saudi Arabia. Moved on to the Milan Police Department as a patrol officer for a couple of years. Went to Canton, worked in patrol, detective, promoted to sergeant, was part of the SWAT team, retired there a few years ago as a sergeant. Most of my experiences with civil asset forfeiture were street level, low level, not for the high level criminal offenders to which this type of legislation was originally intended. Most of the forfeitures I dealt with were $5,000 or less, and they targeted regular people or lower income type people. I'm here to support these bills today. I'm going to try and sum this up as quickly as I can because I know you're short on time. As a prior law enforcement officer, I took great pride in my work, in my criminal cases, in the work that I submitted to a prosecutor or a court as a patrolman, as a detective, as a sergeant. I took great pride in my work, and when I submitted something to the prosecutor or the courts, I submitted that with the intent on getting a conviction. I was confident in my cases, and I was submitting it for a reason because I was confident in that the prosecutor would be okay with my case, and we could win that with that thought that we could win and get a conviction in court. So my question is, why would we not hold our police officers to that high level of standard? Our officers should be held to a higher level of standard, and a lot of times they're not, and that's another discussion we could have. But why do we not hold them to a higher standard in cases of civil asset forfeiture as we do in the criminal cases? As a police officer, if I'm going to forfeit property and there is a conviction required for that, I should have the confidence in my case that I'm going to get that conviction and we are going to be able to lawfully seize that property. So I don't understand why law enforcement should have any objections to a conviction being required in order to seize a person's property. They should have confidence in their case. They should be professional enough to put together a solid case that if they're taking it to court and taking it to prosecutor, that they are going to get a conviction and they will be able to seize the property. So why would we not hold the officers to this standard? Anytime we're taking we hold these officers to go out and they can arrest people. Not too many people have the power to go out on the street and put somebody in handcuffs and take their freedom away. And we give that power to our police officers. And why wouldn't we hold those officers to we hold them to a very high standard for that. Why wouldn't we do that when we're in respect to people's property as well? We are in the United States. It's a free country. And we want our police to act professionally, and they should have confidence and professionalism in their cases and hold themselves to a higher standard, whether it be a criminal case or the civil asset forfeiture to go along with that case. So why would they have a problem being held to that standard to bring their best case forward to get a conviction in order to get the civil asset forfeiture? I don't think that's an unreasonable thing to ask of our law enforcement community, and that's my input for today, and I'm in support of this bill. There should absolutely be a conviction required before we can take people's property from them.
Thank you. Any questions from the committee? Apparently not, so thank you very much for your
Thank you
time.
for your time today. It's truly an honor.
Thank you. And next we have Diane Ferguson, who is in support of, neutral, but wishes to speak.
Hello. I'd like to thank you for setting aside the time to hear public comment on House Bill 4168, and I would also like to thank Mr. Lucido for introducing the bill. Can you hear me better now? Okay. Do you want me to repeat what I said or just keep going? My name is Diane Ferguson, and my home was raided on January 9, 2014. I was a patient and a caregiver for a majority of cancer patients. My baby sister had cancer of the heart. I had a federal agent who came to me with a medical marijuana card. He also had cancer of the mouth. Literally, truthfully, he really did. And he was a St. Clair County Drug Task Force, also Border Patrol at the bridge in Port Huron. Our case is really messed up. I mean, when I tell people what happened, most people can't believe that it happened. And had I not lived it myself, I probably wouldn't believe it either. We were subjected to civil asset forfeitures twice. Once by participating in the Medical Marijuana Act, being a patient and a caregiver, and like I said, a drug task force impersonating a police officer while having cancer, while carrying a gun, and having a medical marijuana card. Something none of us can do. Had I done any of that, stolen somebody else's identity, or forged the card, and another question is, where did the card come from? Well, my civil asset forfeiture attorney, who happened to be a prosecuting attorney at one point in St. Clair County, informs us that those cards came from Melissa Keys, the prosecuting attorney in St. Clair County. She took all them drug task force officers behind doors and fabricated them cards, and he witnessed it. But yet nobody has called a red flag to the corruption that's going on inside these courtrooms. Second of all, after he told me that, I thought, no way am I going to get a fair trial with this guy. He's in on this. So I went, got a criminal offense attorney by the name of James D. Wines out of Ann Arbor, Michigan. Big mistake. I hired him. And less than 30 days after I hired him, he started committing fraud in my bill. My husband and I both were charged. Him with 2 counts manufacturing and delivery, me with 2 counts manufacturing and delivery, which eventually became 1 count of manufacturing and delivery and 1 count of aiding and abetting. Although they never retrieved the money from both sales, as they claimed there was 2 sales. There was never any money retrieved from one of them sales, apparently, and then when they raided the home, $200 that they claimed that, well, $200 came up missing off of me, what they stole off of me from my home. Also, medibles. Medibles and medicine was never even listed in the list of stuff that they took. Well, no, why would it be? Somebody's got cancer, and obviously their cancer is more important than my sister's cancer. Because after they raided me, she died. And it left 2 children with no mother. In July of 2014, we buried her. And grandchildren never get to see their grandmother. My niece is graduating this year. I'm pushing her to be an attorney. Because we got to have somebody who is fighting for us. My civil asset forfeiture attorney after I was convicted and I was found guilty, because there's this magical little thing, and for the most part, I support your bill, but I don't support the conviction because it's too easy to get it. You see, a motion in limine filed by the prosecuting attorney eliminated. I couldn't tell the jury I had a card, a medical marijuana card. We couldn't mention the names of overages. We couldn't even mention the word overage. Absolutely no defense whatsoever. I sat there and I got convicted in 15 minutes. I was convicted guilty. That jury never heard 90% of the evidence. It was buried. When they came into our home, I was home alone. I live in Sanilac County, and St. Clair County raided my house with Sanilac County. Yet I was convicted in St. Clair County. After I was convicted, the attorney turned around and filed a suit against me and my husband for attorney bill. Yet he had worked with other attorneys, so he said in his bill. And the plan was that if the prosecuting attorney filed a motion in limine, we were going to file interlocutory appeal. But he kept saying, now is not the time, now is not the time, now is not the time. And the day after that motion in limine was granted, I'm going to trial the next day.
We're going to have to wrap it. We're over our time. We're allocated.
So the attorney took me to court in Sanilac County, and I proved that he committed perjury. Because, you see, one of those attorneys listed in my bill, he was a good man. He came forward, and he gave me an affidavit stating he had never spoken with that attorney ever, unlike some of the other attorneys in that bill. He took us to court. He sued us. I proved to the judge, visiting judge, that he had committed fraud throughout the bill. I walked in with an attorney's affidavit. Mr. Wines turned around and filed a contra affidavit. I proved that he perjured himself in the bill.
Okay, we got to state the specifics of this bill. Can you wrap it up? We're, like I said, we're over our time.
And they still awarded him his summary disposition. So they came out and started confiscating our belongings, stealing our vehicles. And I still have that judgment on me today, and it has ruined my credit. Now, let me tell you what civil asset forfeiture did. I used to have my grandbabies at my house 5 to 7 days a week. I haven't seen them for 3 years. Because of the stigmatism on this cannabis. Cannabis is my medicine, and I'm going to use it to the day I die. Other than that, I support this bill.
Well, thank you for your testimony. Do we have any questions from the committee? Apparently not. Well, thank you for coming in and giving your testimony today.
You're welcome.
We have a few cards here that are not wanting to speak. We have Blaine Coops of the Michigan Sheriff's Association opposes the bill. We have supporting the bill Tony Daunt of Michigan Freedom Fund. We have supporting the bill is Pete Lund of Americans for Prosperity. We have supporting the bill Charmine Golston, Michigan Moms United. We have supporting the bill Jarrett Scroop, Mackinac Center. Supporting the bill is Kimberly Budin, ACLU of Michigan. And I believe there was a committee member that may have had another question for Representative Lucido. Pardon? Oh, no, I guess. Okay. With no further business before the committee will stand adjourned.